Jason's down there making it escape. Oh, we have to. But I don't want to really. I think
Okay.
Chair Edson, just before we get started, I just want to say thank you for the good citizenship that put those chairs up, and I think that was very polite. Appreciate that.
Yes, thank you for that.
So at this point, we would like to get direction on indoor cultivation. Previously, Director Maurer had recommended a CUP for A1, or excuse me, 1A, 2A, and 3A indoor grow sites. It's my understanding that he would not recommend any changes to that other than potentially the 1A license.
That's correct. So initially I was thinking more of sort of the industrial scale, indoor cultivation, and it seemed really appropriate industrial zone. However, given the fact that a lot of the outdoor cultivators also have an indoor component, and it's likely that a separate indoor license may be required by the state, I would suggest that we require the zoning clearance certificate for a 1A license for the following zones: unclassified, agriculture, rural residential, general forest, and general agriculture. And that's up to 5,000 square feet.
And we'll look at the Williamson Act question for that one later.
Yes, I guess that's a separate question, whether or not we're going to allow cultivation on Williamson Act property. Yeah. Sorry to repeat that.
So, Peter, on the for indoor, on the light industrial, general industrial, and business park, are you recommending a CUP across the board?
For the industrial zones, yes.
So, would you, on the is there a possibility on those to do AUPs on the license 1A and 2A? Because of the size of the grows you're talking about in regards to those
Certainly.
zones?
Yeah. I mean, if that's the desire of the board, we could do that. Again, the process is very similar other than the final approving authority.
Yeah, I'm good with that recommendation from Peter, and one with Debbie as far as dropping that down. I'd like to look at that a little bit closer, on the size of the operation. I mean, if you have a really small indoor grow, maybe not tonight, but at some point soon, we could look at, the smaller ones, for our local ordinance, having just a zoning certificate code.
So you're suggesting that the 1A license in the industrial zones also be a zoning certificate?
Well, across the board in the recommended zones that you said, as well as the manufacturing zone, if it was up, if it was a real tiny operation, I mean, I think the 5,000 square foot is the highest there, but you could have something that's much, much smaller. Does that make sense, or am I not?
I think our intent was to try to keep our permitting in the same scale as what the state, so that we don't have, differing permit requirements, so that, people know this is the type of permit you have to get. You get this one from the county, this one from the state. We could create a different hierarchy of permitting. I think it just makes it more complex than we necessarily want it to be.
Okay.
Just so the board is aware, the 1A license is for up to 5,000 square feet. The 2A license is
10,000.
up to 10,000 square feet, and the 3A license is up to 22,000 square feet.
Yeah.
AUP, I think, probably would fit in this.
I do have a concern about the 22,000 square foot limitation, but I think it's the same process. We have the ability for the appeal there, so I'm good with change that to AUP.
And how about the zoning clearance for the smaller, on the residential and agricultural zones?
Let's do the light industrial first.
Okay.
I'm good with the AUP on it also. I have concerns about even allowing the 22,000 square foot indoor. That is a very, I worked my way through college in greenhouses. That is a huge greenhouse. And I really think we need to take a look whether that is even the appropriate one we want to go for here.
Why did you put CUP down there, Peter?
I think just for the very reasons it's it could be a very large-scale operation, just provided enough oversight by the county that if that's, that's the most appropriate location and there's adequate security and all the other things we need to look at. And it's a range of 10,000 to 22,000 for the Class 3.
On 3A?
For 3A. Can't exceed 22,000.
Peter, can you clarify too, say under a 3A, can it be two separate buildings? Is it looked at as one big building?
I believe so. I think it's a total amount of cultivation area.
Total
So if they have
amount.
multiple greenhouses, it's all on the, how much on one site.
Okay, Yeah,
Yes,
but
it's
I
total
would do-
canopy size on one premises.
yeah. I'm for AUP on the 1A and 2A and a CUP on the 3A.
And what's the size on 2A? Or, 2A?
Up to 10,000 for 2A, up to 5,000 under 1A.
I'll agree with that. CUP on 3A.
After reconsidering, yeah, I would go with that too, Supervisor Pontes, the CUP on the 3A.
Okay.
Yeah, the 10,000 is big. 22,000 is 22,000. Is like the size of a grocery store. Well,
43,500.
okay, I guess I think in terms of what I did for a living for 30 years, 22,000 feet is like the size of a fair-sized grocery store floor. Okay,
I got to tell you, I'm not even in favor of having something that size.
I truly am not either. The thing.
You guys were pro-growth.
I don't think that has anything to do with being pro-growth. There are a lot of things that go with a 22,000 square foot.
That would be pro-big money coming in and putting our little guys out of business.
I'm just kidding, I'm sorry.
A 22,000 square foot greenhouse also includes leach ponds and all sorts of things that we haven't even begun to consider.
I am not for something that big, so the rest of the board can weigh in on that if they'd like.
Well, I'm not for something that big in the indoor either.
Did we discuss that issue now?
We're looking for direction from the board. If you would like to
We
direct
can
us.
eliminate 3A altogether.
The prior direction of the board was to allow for CUPs in the 3A permit category. If the board wants to direct otherwise, now would be the time to do it. We can modify it and process things forward. Again, any direction you give us today can be changed in the future. This is just direction so we can move forward. But whatever direction you give us tonight, you won't end up seeing the ultimate product until it comes back after it's been processed through the Planning Commission.
Thank you, Council. I must admit, in my research and in my prior time before sitting down, I did consider those quantities listed, 5,000, 10,000, and 22,000. I was looking to cut those in half. But I did make a consensus that the 5,000, 10,000 is good. But now that you bring up the 22,000, I do see some problems with that. And I would agree with Supervisor Edson, Supervisor Kearney, that we eliminate the 22,000.
So then the direction from the board would be to not allow any 3A licenses within the county, to allow AUPs for a 1A and a 2A license in the M1, M2, and M4 zones, and for it to be permitted for personal use, caregiver grows in the unclassified, the highway service, residential ag, rural residential, single-family residential, general forest, and general ag and ag preserve.
Roger that.
So we're taking 3A out altogether?
That was what I heard from 3 board members. Correct me if I'm wrong.
I don't know, I mean, if,
That's 22,000 feet.
but it's all
So then the
indoors.
limit of indoor cultivation would be 10,000 square feet in the county,
Indoor.
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 Indoor where there's no odor, in a very controlled atmosphere, very controlled environment. Those were some of the concerns I heard today.
Still got 1A and 2A.
A 10,000 square foot greenhouse is very large. A 22,000 square foot greenhouse is, you just don't see that many of them.
And this isn't a greenhouse. A greenhouse would fall under the
Warehouse.
mixed lighting category. This would be a fully in, like a warehouse building.
I understand
100%
that.
out, in artificial lighting.
I understand that, and maybe it's a bad play on words, but I still would rather get rid of 3A.
Okay.
Okay. So then the last question on this would be whether or not we want to allow indoor cultivation on the residential agricultural zones. I suggested the zoning clearance would be appropriate in unclassified, res ag, rural res, general forest, and general agriculture. Just for 1A.
I would say yes.
Just for 1A?
Just for 1A, up to 5,000. And that would accommodate the current, what I understand to be the majority of the process that is allowed, that is currently the practice of the growers here in this county.
On which one is that? 1A?
So under the 1A license, would allow indoor cultivation on those selected zones with that license only.
On a A1 and an AP?
Under, well, I'm suggesting a zoning clearance. The outdoor cultivation is a zoning clearance for the same size.
So up to 5,000.
Up to 5,000.
So what Mr. Mauer is proposing is that for the 1A license, there would still be an AUP in the manufacturing zones, the M1, M2, and M4. But what he's proposing is that there be a zoning clearance certificate for the 1A license in the unclassified, the residential agriculture, rural residential, general forest, and general agriculture. Is that correct?
Right.
So what about something that's actually smaller than that?
That's a good idea.
You know, that they, that could be up there.
Well, anything up to that size, and if we want to set a lower limit, we could do that. It complicates things a bit, but we could certainly do that if you want, say, up to 2,000 square feet, or whatever the number might be.
And just so the board knows, the 1A license is for any indoor cultivation using exclusively artificial lighting of less than or equal to 5,000 square feet of total canopy size on one premises. So that would include anything that was smaller unless it was a personal use grow or a caregiver grow, which is addressed in a different column.
So you're asking for a ZCC on exactly which ones now?
For a 1A license, unclassified, res ag, rural residential, general forest, and general agriculture.
I would support that.
That's fine.
It's all, it would be indoor, correct?
Correct.
Only, we're not talking outdoor cultivation.
They would need a separate
One
license for outdoor
license.
cultivation.
Okay, and we've covered that. I know I'm repeating myself a lot, but it has been a long day, and I'm trying to make sure that I got it completely understood. I would support it.
That'd be 3.
Okay.
I think that's all I had as far as zoning's concerned.
So at this point, I know that there have been additional staff that have stayed to address the Williamson Act question and as well as the enforcement questions. So I would just ask that we hit those 2 items, and then because it is getting so late, if there is any broad policy decisions that the board would like to direct us on, and then let us move forward with processing this with broad discretion and broad direction on any other issues. That would be appreciated, and then we can call it a night.
Okay?
So start with the Williamson Act question. Would the board, does the board want to allow qualifying cultivators to enter into Williamson Act contracts? And does the board wish to recognize lawful cannabis cultivation in the A1 and AP zones as legally existing agricultural land uses for purposes of its right to farm provisions? Those were the 2 ag questions that.
Right to farm has a definite, or a specific definition.
Well, yes, we have an ordinance that describes what the right to farm and how it applies. And the question is whether or not we want to provide an exception for right to farm provisions of our code for marijuana cultivation.
Typically, right to farm was put into place to, it was mentioned earlier today, it was put into place to address urban encroachment onto agricultural uses and agricultural lands to deal with any nuisance issues. Certainly, the way that our ordinance was drafted, it was very liberal in what it would encompass. And so what staff is asking is if the board would want to include or to exempt cannabis from the right to farm provisions of our code.
Our office's interpretation of state law, as I explained at the last meeting, is that the Board of Supervisors has the discretion to determine whether marijuana will be considered a crop for purposes of its own zoning code. And I know, because again, the way the state wrote MRSA simply said that it's an agricultural crop for purposes of MRSA. And so that language suggested to our office that the board does have discretion to make its own determination. And that's why we're asking that question.
Well, I'm confused then, because I've been hearing everybody here talk about how their tax dollars are going to help Calaveras County, and now we're making a statement that says, hey, by the way, we're going to give you a cut rate on your tax dollars.
Right to farm is different than Williamson
Kinda
Act.
weird.
They're 2 different issues.
Yeah, but the question was Williamson Act.
That was there's 2 questions. One is whether you want us to exempt marijuana from the right to farm. The other is because this was brought up at the last meeting, or the last meeting in January when we addressed this, there were questions about Williamson Act contracts and if the board wanted to.
So if we
the
want to
board-
exempt right to farm, that means that it would be different than whatever other policy is out there for right to farm. Is that what you're saying?
It would just not give it the protections of right to farm.
I would support including it in the right to farm.
Yeah. I support the right to farm and also the Williamson Act.
I have personal friends in the agricultural business in San Joaquin Valley, large, and this has been a real hot topic. At this time, I would not support that the cultivation of cannabis is a right to farm issue.
What does being included in the right to farm, because I've been reading about it, give them that they wouldn't have otherwise?
So the right to farm provisions of our code provide protection for a farmer from nuisance complaints due to normal agricultural practices, noise, dust, odors, those kinds of things that are sometimes offensive to neighbors. And as Ms. Stedfeld pointed out, our ordinance was adopted in order to protect the farmers from encroaching urban development, where people move out, oh, it's so beautiful, buy this ranch or buy this vineyard, and then suddenly they're woken up at 3 o'clock in the morning because that's when they can spray and it's noisy. And the right to farm provision protects the farmer from nuisance complaints.
All right, in this case, it's kind of reversed, though. I mean, I could see once you're established and you have an area which you're farming and then residential moves in on you, then I could see that as being a viable option. But right here, what we're having, and from what I hear everywhere, is we're actually moving farmers in next to the residential areas. And so where are the residential's rights in this? That's the question.
Well, I think that is the question. And if you don't mind me jumping in, I think from the right to farm, again, does the board want to give them the same rights that somebody who is doing what we consider traditional agricultural practices? If the board does have concerns regarding grows being brought in next to residences, then do you want to indeed afford them the same protections that the other people have in the traditional agricultural world?
I do not at this time. This is a new experience for all of us. And as I said once before, it's changing the landscape forever. Maybe 2 years down the road, it's a whole different gig. And this community has proven that they're good neighbors and good citizens. I can't predict that future, but I do not support including them in this at this moment.
Now, if we were a couple of years down the road and you had a farm, and then somebody bought a big parcel next to you and wanted to develop it into a housing tract, and then people started moving in, and then they started complaining about your farm. That's what right to farm is for.
We do have a Cliff, kind of part of the problem is that there's already a lot of established farms out there, marijuana farms out there. So it's not like, it actually is like that already. The problem we have is that it's not we don't have that documented as a legal use necessarily. So it's hard to track that. But I think that there's a lot of people who've been farming for decades. And so you're going to have you have that issue that you're just talking about right now. It's already there.
What I've been hearing is the folks that have been farming for decades have found a way to mitigate their issues with their neighbors, and they don't really have a problem. It's the ones that are moving in now next to people that have been established here for a very long time, and they're having issues.
Yeah, I agree. I've heard that too. Yeah, I mean, it is an issue. But I'm just saying that, that kind of both are going on.
Yeah, but I think, like Steve said, a couple of years from now, it could be a whole different situation, and we may end up in that. But right now, I'll just say that I don't agree with the right to farm. I don't think it applies here, actually. So we can revisit it if it looks like it's, you know, everything is evolving and changing. But right now, I don't agree with it.
So Kevin, do you have any comment on that?
Well, as it was previously stated, the right to farm, now our ordinance is for if the grower is established and it's being encroached by development. That's exactly what our right to farm ordinance states. As I said earlier, I thought that that these things would work out if the zoning was a little stricter. But right now, the way that we've passed it, we could have a rural residential area of 1 acre with a 1/4 acre of marijuana on it. And so I think that could be problematic, and just someone coming up with the defense that I have the right to farm could be a problem. So I think postponing it for the time being is probably wise until these other things, we see what happens.
And may I just propose something that the board may want to consider? Our code specifically says any legally existing agricultural land use. And arguably, once we get this ordinance in place, allow the growers and cultivators to become legal existing agricultural land uses under our existing code, because right now we don't have an existing zoning code for them to be legally existing under our local code. So if, once we get this ordinance in place, allow cultivators to come into compliance, be permitted, show that they are legally existing agricultural use in the community, certainly this is something that the board can reconsider in another year, another 2 years in 2018 when the state permitting process is in full effect, where we can, at that point, local cultivators would be able to show a long-term permitted existing legal use within the county, legal pursuant to our code.
So, and I got to tell you, I don't think we'd have an issue with anybody out here. But once this begins, you guys, it's not going to be just you. And so I also represent folks that are currently living in these areas. And I mean, I'd like to see something to protect them too. I mean, what have we thought of to protect the residents that are currently in areas where people are just gonna, buy up a bunch of property and move in on them? And if you were in that position, because you have been actually for quite a while, of not feeling like you have much standing, then you would probably think a little differently about some of this stuff. So I don't know how to even address that, to tell you the truth.
Yeah. Well, I think we did come up with the fact that the majority of the board does not want to include right to farm right now, right? So
Right.
we can move on to the next part of that question.
The next part is Williamson Act. The question that I would have is whether the board wants to allow for cultivation under Williamson Act contract, and if not, would the board want the ordinance drafted in a way to, if it's already under contract, would you allow for cultivation to occur if they filed all of the paperwork to start the process to get out of the Williamson Act contract? Because as the board knows, it is a lengthy process, a multi-year, 9-year process to get out of the contract.
Anybody in the Williamson Act right now?
That is a legal grower, or that I know of? No.
Yeah.
But I heard
There
that
is?
there are some grows on Williamson Act property, but I don't know of them exactly where they would be. I think, like I told you, I have had conversations with the Department of Conservation, and they tell me that they are working on this problem themselves, and that the gal who wrote up their recommendation has sent it to their lawyers. and their lawyers are now betting it to see if what she wrote, which she wouldn't tell me what she wrote, is going to fly. So it's gone that far down the road. So I thought that since we don't know what they're going to say and what their guidance is, and that most of most of the ranchers in our county are willing to wait until we get some guidance from the Department of Conservation, that perhaps by the time it comes back here from the Planning Commission, that we'll have better guidance.
Maybe we can be creative with it too, because I'm just having a really hard time with that right now.
And Kevin, does the county, are we still not receiving any funds?
Yeah, no funds.
So I'd remind the board that in the past, the county did receive funds for kind of a backfill, if you will, pennies on the dollar for Williamson Act properties. The conservation program in Williamson Act was designed for preserving open space as well as agriculture. And for a long time, the state of California provided a subvention, if you will, again, pennies on the dollar, back to the local jurisdictions. During the 2007 crash, that ceased to exist. Kevin, correct me if I'm wrong. And at this time, we are still not receiving those subvention dollars. So again, it's another item for consideration, because at this point, if you do go with Williamson Act, keep in mind that there is no subvention.
Yeah, I kind of agree with Cliff. I think he had a good point there that we can be creative if they do say that it's a product or a plant that can be considered for the Williamson Act, that we can be creative, because really it's kind of disingenuous to say that we're going to give a tax break for a crop that we're really that's going to cost the county money to enforce the new ordinance on. So perhaps a surtax on.
We don't know how it's going to look.
Yeah, we don't know
right
how
now.
it's going to look, but
So,
we can be.
Yeah, I don't want to destroy anybody's opportunity that's already in that.
Yeah.
But I certainly don't want to add any new language for it.
Yeah.
I would agree with that. For just temporary, you want to just have it's okay for existing contracts, but not new ones? Is that?
Well, I guess the question would be, do you want to allow it if they're still under contract or if they are in non-renewal status? So they can.
Either one.
The question was, one, do you want to allow it if they're under contract? Yes or no? Two, if you don't want, alternatively, you can allow for it if they're in non-renewal status, but over time they will eventually get out from under the contract, but it will take time. So as long as they're under non-renewal status,
We don't know
then.
if that's the way it's going to be yet.
What do you mean?
We don't know if that's what we're going to choose.
What the Department of Conservation is going to rule, we don't know.
She's just asking if we want to have it allowed at all under existing contract.
I would say that I am willing to just move right on past that one.
Well, the question is, does the board wish to allow qualifying cannabis cultivators to enter into the Williamson Act contracts? No.
Enter in.
Those
No.
would be new contracts.
Right. No, I don't think we are. At
Okay.
least I'm saying no.
would
Now,
be the question.
further, she's asking if we want to ask them to start to get out of their contracts.
Right.
Because as we know, those take a while to do. I would say at this time, no, but I want to play on the words "at this time." We could, because the Commissioner Wright is telling us that we don't have all these answers to that yet, and so that's my vote.
So then the follow-up question is, what about folks that are currently under contract that would like to grow, or that are already growing and want to continue next year? Because right now, under the code, the way I have written, it's not permitted, except for personal use or caregiver.
Why is it not permitted?
That's our question we're trying to answer now.
That's just the way we wrote it, because we had some questions about how it would apply to the Williamson Act. The concern that I guess I have is, my staff has been processing these applications recently, is that the amount of revenue required to qualify for the Williamson Act is probably less than you'd produce off of one plant. And it seems unfair that would be a qualifying crop to meet that very low threshold for the income requirement. However, I understand there are people that are under contract, and maybe in addition to their cattle operation or their grape growing or whatever it might be, they also have some marijuana under cultivation. And would we permit that to occur on existing Williamson Act contracted land?
So that is something that, like Kevin was saying, when we get a little bit more answers on this, maybe we can make that decision.
Yeah. So right now, as far as the old ones go, they're in their agreement that they signed with us to start with, they have to have a plan, and there's not a single one of them that has marijuana in their plan. It's cattle. That marijuana hasn't been mentioned by anybody. And maybe somebody's son or nephew is out there with this little grow. Or also, there may be people approaching the ranchers to lease a little piece of property and pay them $30,000 for that. But those are hypothetical as far as I'm concerned right now.
I think it's really important to reinforce what Kevin is saying. The existing contracts out there are not based on grows. They aren't based on cattle, they're based on grapes, they're based on your traditional agricultural products. Would you agree, Kevin?
Yes.
And so I think that the grows would, at this point, would be irrelevant.
Well, Brian, but there's an important point, I think, though. That's true, but what I don't want to see happen is if somebody's, they haven't included that as part of their contract, but they also happen to be growing, and they meet all the other legal requirements in our ordinance, but they're not allowed to do that because it happens to be right now in a Williamson Act. So that's why I think we should have it for existing grows, existing contracts they're allowed to grow in.
I think that, I don't think that would prohibit them from doing a grow on an existing contract, because the contract has.
No, not the contract, but the zoning. We don't allow it in the zoning right now.
I see, for the AP? Is that the issue? It's the AP?
Right.
Okay.
That's the question.
Got it.
Yeah.
Sorry about that.
That's okay.
So I would agree with Supervisor Wright that there's sort of two separate issues. One is allowing the value of the crop to meet the qualification requirements that are entered in the Williamson Act versus allowing someone who happens to be in the Williamson Act to also grow marijuana. And if it's the board's desire to allow someone who is currently under contract that meets it by their grapes or almonds or cattle to also get a permit to grow marijuana, they could do that. In which case we would need to change the table as far as the agriculture preserve zoning and modify that.
What if the Department of Conservation?
And I would, if that's the desire, I would just have it the same as we do for the A1 zone.
The only problem is, what if the Department of Conservation says that that's not going to be something that they allow?
But they're qualifying under a different crop. But if for some reason the Department of Conservation makes a ruling that says someone under contract cannot grow marijuana, then they're in violation of their contract and they need to make a choice. They pull out the marijuana plants or they pull out from the Williamson Act.
Okay.
Okay. You guys figure it out. That's why you get the big bucks.
Yeah, you're laughing. You should be sitting here. I still stick by at this time.
Yeah, so, Steve, can we recap where we're at then, I guess?
So I think the decision is whether or not you want to allow someone who's currently under contract that didn't qualify because they're growing marijuana, but by their other crops, to also grow marijuana. without getting any additional benefit from the tax breaks,
Without marijuana being the qualifier.
without marijuana being the qualifier, correct?
Let me just say one more thing. Generally, it's not the cattlemen who would be doing the growing to begin with. What they would do is lease an acre of land to somebody else to grow. The cattlemen have enough to do without growing marijuana. For the most part, they aren't interested in growing marijuana.
Happy cows.
But some of them
gotta cook it first.
probably wouldn't mind leasing an acre to another person to come in and grow the crop.
All that will come out when you get your report, but, you know, as it stands right now, I don't think that we are in a position to recognize the grow as a qualifier. I mean, if somebody's out there already, with cattle or grapes or whatever, within the Williamson Act, great.
So to just clarify, in case the board isn't aware, there are 3 requirements. You have to have minimum acreage, you have to have minimum production, annual production off the land to meet the qualifications. Kevin, what's the third, or is it just those 2? $2,000 of annual income off the agricultural crop. Just 2 minimum acreage and that, or is there a third criteria?
Acreage-wise, it's a little bit convoluted, but it's 100 acres for rangeland, 50 acres for
Horticultural.
other crops, and then if it's less than that, by an action by the Board of Supervisors, they could
I didn't want to get
something
too
special.
down in the weeds on that one, but we have 2 criteria. You have to have a minimum annual income and minimum acreage to qualify under the Williamson Act.
Yeah.
But we're not talking about qualifying, we're just talking about adding,
That is an additional use.
yes, that zone, you can grow marijuana regardless of the contract.
And
As long as
so,
you meet all the
It's
other
not gonna affect their Williamson Act contract. And the other question was, about Williamson Act, where was it?
Third from the
Yeah,
bottom.
so does the board wish to allow qualifying cannabis cultivators to enter into the Williamson Act? Not at this time. Not at this time. No, we need to hear more from what Kevin was talking about.
Conservation.
Yeah.
so what was the consensus there, or has there been one? Yeah.
I think the consensus is it's okay to continue in if you already
Yeah, but we will not consider it as a crop for qualification at this point in time until the state comes back with rules and regulations.
Correct.
Okay.
Correct.
Yeah,
Got 4 on that one.
all right.
Yikes.
And then the next one is, okay, so the question though is, does the board wish to allow qualifying cannabis?
And you guys, the majority on that said no.
No.
Yes.
Okay, so now, should we adjourn?
What
Yeah,
else you
the
got?
I don't think we're not making much progress in this one.
No, at this
She
point,
asked for some broad
the only thing
guidance.
that I would like direction on, because we still have Todd Barr, who has been here all day long with code compliance, to address any issues or concerns that the board has on enforcement. And I know enforcement was brought up on public comment. So I did want to bring up just some issues with the enforcement. A lot of areas of our code does have a criminal element of it. We typically pursue all of the civil side through nuisance abatement rather than through any criminal infraction or misdemeanors. But there are a variety of areas of our code that have that as kind of a safeguard to fall back on if we needed. But typically that is not I'm not aware of any time that we've actually used that area of enforcement, but rather through nuisance abatement, through code compliance. Todd, you can chime in on the process.
Yes, it's been about 14 years since we used since we went through any criminal court concerning nuisance abatement, land use, or building code violations. We've found that the administrative process is much more effective. By issuing the administrative citation, there are actually sanctions that are available, up to $50 per day per violation, and those can get rather they can get up there. We try to cut them off at a certain point, and the whole point with using the administrative process is it gives us an opportunity when there are violations that we can actually work with the people that own the property and that do have the violations on their property. Just gives us some more flexibility there, and it avoids a criminal charge. 8.06 Public Nuisance Code does provide that land use and or building violations can be charged as a misdemeanor, but like I said, it just hasn't been what's been effective for us over the last 15 years and just hasn't worked. So, do I have any questions?
Just to clarify, they can be charged as a misdemeanor, and that's at the discretion of code compliance?
Yes, sir. They can be charged as a misdemeanor. That'd be through a referral to the district attorney's office. Like I said, the administrative process has been much more effective. What happened is when we went through the criminal courts, when we had violations that needed to be abated, we couldn't actually go in and do it. We could not get an order from the court to go in and eliminate the hazard of the violation. So through the administrative process, we're able to do that, and we're able to bring it to a close, and then also, when necessary, do the cost recovery that we have to do also.
So that brings up another question for me because of this part of it. Part of the problem is being able to access properties, right?
Yes, sir.
Okay, so is there something in this application that is going to, a right of entry form is going to be signed for people that are registering?
Yes, so all of our applications have a right of entry consent statement that by filing the application, they give consent for us to inspect. It'll be written component of the application.
Just like my restaurant.
Just like your restaurant.
Director Maurer, is that the right of entry for any reason by any person, or is that limited to?
Under the normal processing of their application or review of the permit once it's been issued. Now, if someone who has not applied for a permit, then that's a criminal violation, I'm assuming. If they don't have the state license, they don't have the county license. So when someone applies for a conditional use permit for some other use, we go and inspect it before we make the application. We also have the right to inspect it once it's in operation to ensure compliance with the condition. If they're operating without a permit, then the first course of action for that would be Todd's office. And if it's something that he feels uncomfortable with, then he would ask for assistance from the sheriff's office.
And Mr. Barr?
Yes.
Personnel in your office, are they considered peace officers?
No, they're not considered peace officers, although we do have some peace officer standards and training, PC 832, search and seizure. We are able to issue citations, obtain warrants for inspection and warrants to do the actual abatement of violations on the property.
So I have a question then. If somebody is operating without a permit, they're illegal.
Yes, that would be a violation of code. Which
Violation
we could.
of ordinance.
Okay.
So why would you be involved? It would be the sheriff's office at that point. Because they're illegally operating, period.
Yes, but that would be a violation of should we adopt this code, that would be a violation of this code. So we are the ones that are tasked with enforcing land use and building and public nuisance codes in the county. Would we take a sheriff's deputy with us? Yes, probably as a civil standby, just to make sure we introduced ourselves to the people and got to know them and got an opportunity to explain to them what was going on. We've actually been pretty involved in quite a few grows over the past few years, some pretty large ones. And we've always been able to, we've actually had a couple that we've issued citations to, but for the most part, we've been able to get to the grow, contact the people, and they were, I'd say I think they were relatively comfortable with dealing with us and the way that we did our business.
Sure, that's really great because right now, none of it's legal, in a sense, but because we don't have an ordinance. But when we have an ordinance, and then somebody is not registered and following through in that ordinance, doesn't that change the game a little bit?
Chair Edson, the way the draft ordinance is written, we've reserved quite a lot of options for the county. The county has reserved in the language right now the right to pursue a violation of our ordinance through the civil nuisance process, which is what Mr. Barr is talking about. There is also the possibility of treating the nuisance as a crime. It could be a misdemeanor. Separately from that, if somebody is actually operating without a license in violation of the MRSA or the state law, there is a separate health and safety violation, which could even potentially be a felony violation that could be prosecuted, and that is separate from the nuisance provisions in our code. So the way it's written is that there's an option there. And I think what Mr. Barr is saying is that, you know, for code violations, we've generally treated them through the civil administrative process. The ordinance is drafted to allow us to pursue them through the criminal process, but ultimately the district attorney would need to exercise her prosecutorial discretion to determine whether or not she feels that she can or should prove up a criminal case for violation of our local ordinance.
So, Mr. Barr,
Okay. Okay.
we've talked about the personnel in your department and the powers, the limited powers they have. Should someone resist or obstruct you in the performance of your duty, is that obstruction of a public official in the performance of their duty, is that a chargeable crime? How would you do that, and how would you handle it? And has it happened in the past?
It has not happened in the past. If we encounter resistance, normally we retreat. Use your head, get out of there, you know, live to address it on another day.
Call the sheriff.
Yes. Get a civil
Wait for the
assist with the
sheriff
sheriff's
to get there,
department.
that'll be 45 minutes.
Yes,
And
but that's it.
Ongoing
We have to wait.
investigation, and the sheriff would come up there and initiate arrest for obstructing a public official in the performance of their duty, right?
We've never had that happen. Once we got the civil assist, then usually people are pretty cooperative.
Okay.
So I can't answer that. I guess at some point you could reach that level. It's just never gotten there.
One last question, and I'll give
Okay.
up the microphone. How many people are you going to need to enforce this ordinance?
That's I guess the grow count, I guess, is between 800 and 1,000 at this point. I see at least one full-time position just to keep up with the inspections that are going to be required on an annual basis. I guess we're just going to I think that's where we need to start. I don't think we need to overload people. I think we need to start there and see exactly what things are going to entail and how it's going to wash out.
Thank you,
Okay.
Mr. Barr.
Okay. Are we good? We're good. Yep.
Unless the board wants to direct us on something else, that is the way that the Ms. Motz-Lewis explained how the ordinance is drafted for enforcement. Unless the board wants to direct us to draft things differently on a broader policy decision, you can do that. Otherwise, we would recommend that we move forward with the way that things are drafted to give options to the county depending on the circumstances.
All right, so my only concern through this whole thing right now is the folks that are currently living there, and new people coming into the area and basically pushing them out. I just really have an issue with that. So I don't know how we can protect them, but we certainly, it seems like, you know, it seems like in California anyhow, all the laws are protecting everybody but the people that need protecting in a lot of cases. And I really have an issue with that. And that could go into, into the cartel arena too. So that's my concern.
Yeah, Mr. Chair, could I make a comment on that issue? I do have to bring this to our attention. In my district, we did have a situation occur where one of our businesses was being subject to, if you will, eviction due to this particular issue. And I must commend Chaz. He was instrumental in talking to the people involved, and that situation turned out very commendable for all parties. It's not a permanent one, but right's right. No, it doesn't mean that's the only situation we have, but give credit where credit's due.
You asked for broad recommendations and thoughts. One of the things that we're not going to go into deeply here, but it's one of your questions and your bullet points, is the taxation of commercial cannabis. Do you want to pursue that?
Yes.
Heck, yeah. And while you're doing that, start to really research how to set up charging some type of registration fee. So, I mean, Todd just brought up he needs another code compliance person, a dedicated other personnel. There were so many brought up. So that is one of the broad things that I'd like you to consider.
Yeah, I would definitely agree with that. I think we should have that, going on this November ballot.
The only other item that I would like direction from this board on is the last bullet that has to do with the current draft ordinance requires residences on the cultivation sites. And I know that there was a big issue, at least at the last meeting, where a lot of the growers lost their homes in the Butte fire. And so there have been discussions and there have been requests that there be an exemption for anybody who lost their home in the Butte fire to have the 3-year grace period, similar to what was in the governor's bill, to allow them to rebuild in that period, but not require them to have the residents on the property for that 3-year period.
I would agree to that.
Yes.
I heard 2. Okay, 3. You got it.
Are we gonna do it for Williams Snack folks?
Is this the commercial growers or is this commercial, all growing operations?
In the fire area.
I would mention anybody, I would recommend that we draft it for anybody who lost, who would be required to get any kind of permit, whether it's a zoning clearance or an AUP or a CUP. If they lost their home in the Butte fire, then they would have the ability to have a 3-year time period to rebuild and reconstruct. So I heard 3 yeses. That was all that I think we've got good marching orders at this point. So
Where are you marching to? Back to us or to the planning commission?
Planning Commission.
So the next steps in the process will be to prepare the next draft, and then we will take that to the Planning Commission. They will review it, make their recommendation, and then we will bring it back to you. And I think we want to get this done as quickly as possible, so it won't linger long.
Is it possible to have that as a joint meeting?
No, for planning and zoning ordinances, essentially when it's before the Planning Commission, it's the first reading. As you know, with other non-planning and zoning ordinances that come to the board only, there has to be an introduction, which is the first reading of the ordinance, and then it has to come back at a later date for the adoption. So for planning and zoning laws, essentially the Planning Commission meeting is in fact the first reading. So arguably we could have it a joint meeting if you want to hear and participate in the discussion, but it's not something that we could do like a first reading in front of the Planning Commission and the board also take action to adopt. No, that couldn't happen.
All right.
No.
And is there a time limit that we can give, like back to the board here in 30 days, 45 days?
Well, whatever Peter's schedule is.
Well, I'm just saying, we're
Yeah.
approaching grow season, and I would hate to see this.
The only concern I have is the necessity to prepare a CEQA document on this ordinance and the time frame that's necessary to do that. Because there's at least a 30-day public comment period, and we need to prepare the document. But we will expedite it because we understand the urgency need. Not official urgency, but the urgency just because of the timing that we have.
All right. And then what if we get to the Planning Commission and they go for a no ban?
Then you can choose to accept or reject their recommendation. It is only a recommendation.
All right. Can we give direction to the Planning Commission that this board, as noted earlier today, that we are no ban?
They have their own discretion to make any recommendation that they so choose. I think they will be very aware of the direction that we have received from you, but no, you can't give them direction.
All right. And if they vote for a no ban, that's advisory in nature, right?
That's correct.
So it would still come before this board for a final?
Yes. Their action is only advisory.
Thank you.
Okay, so we good?
I think so.
Yeah.
Thank. All right, so we still have, we're actually still in the meeting. So we still have board member announcements. Anybody? None? Wait, Mike does.
I'm going to reserve mine until next board meeting.
Steve?
Wise man.
I just want to thank everybody that made it this far. This was an emotional meeting. You did a good job.
Thank you, guys. All right, meeting adjourned.